Mr. Speaker, I rise in strong support of the Senate amendment to H.R. 8404, the Respect for Marriage Act. I first introduced a version of this legislation in 2009, and I am very proud that after a long journey, it will soon be headed to the President's desk, and marriage equality will be enshrined in law. The House took an important step in July when it passed the bill with support of 47 Republican members. Now that the Senate has passed an amended version, also with bipartisan support, it is up to us to finish the job. I find it deeply poignant that as we prepare to bring the 117th Congress to a close, we are on the cusp of a great bipartisan moral victory in the defense of a fundamental right of all Americans, a victory that will provide stability and reassurance to the millions of LGBTQ and interracial families that have come to rely on the constitutional right to marry. The Respect for Marriage Act does three things. First, it repeals the so-called Defense of Marriage Act, which blatantly discriminates against same-sex couples and which still officially remains on the books. Second, it enshrines marriage equality for federal law purposes, requiring the federal government to consider a person to be married if the marriage was valid in the state where it was performed. Finally, it prohibits anyone acting under color of state law from denying full legal effect to a valid out-of-state marriage based on the sex, race, ethnicity, or national origin of the two individuals in the marriage. The Senate amendment does not change any of these substantive provisions. Rather, it adds language that explicitly affirms that existing constitutional and other legal protections for religious liberty remain in effect. The Senate amendment does not create any new substantive legal rights, but rather it clarifies that the bill does not affect the existing legal rights or benefits of religious persons or entities. It also explicitly clarifies that the bill does not require or authorize the federal government to recognize polygamous marriages. It is because of this compromise, the result of the hard work of Senators Tammy Baldwin and Susan Collins, that the amended bill passed the Senate by a vote of 61 to 36, with 12 Republican senators voting in support. While marriage equality remains constitutionally protected today, we have learned in recent months that rights once thought to be fundamental and forever secure can in fact be taken away. Indeed, in the Supreme Court's decision in Dobbs versus Jackson Women's Health Organization, a decision overturning nearly 50 years of precedent recognizing a constitutional right to abortion, Justice Clarence Thomas went out of his way to write a separate concurrence calling on the court to reconsider all of its substantive due process decisions, including Obergefell versus Hodges, the decision recognizing a right to marriage equality. In light of this concurrence, even if one accepts the Dobbs majority's assurances that the constitutional right to marriage equality is settled law, Congress must use this opportunity to provide additional reassurance to the many American families who have come to rely on this guarantee. After all, we were told that the right to abortion was settled law also. The Respect for Marriage Act cements respect for married couples, which all Americans, including those in this Congress, should support and value. I want to thank the co-chairs of the LGBTQ+ Equality Caucus, the chairs of the Congressional Tri-Caucus, and incoming House Democratic Leader Hakeem Jeffries for joining me in introducing this legislation. I also want to thank my Chief of Staff, Amy Rutkin, who has done so much to help guide this legislation through the House. I urge all members to support the Senate amendment to H.R. 8404, and I reserve the balance of my time.